All right. Hi. Okay, welcome back. Thank you all. Questions? Anything in your minds? No? Okay. We are continuing today our discussion of easements. And again, easements is basically permission to cross over someone's land or to use someone's land in a way they may not otherwise want you to. So let's do a polling question to start off today. It's on the board. Okay. Question says, Adam, who owns Wet Acre and Dry Acre, conveys Wet Acre to Betsy. But Adam retains the right to use the lake on Wet Acre. The question here, what is the dominant estate? Adam, Betsy, Wet Acre, Dry Acre, none of the above. Excuse me. Okay, another 5 seconds. All right. All right, who's next? All right, Esther, what do you think? Okay. Well, let me ask you a few questions first, all right? We'll get to the right answer in a minute. Esther, why is it significant that Adam sold Wet Acre to Betsy, but he retained the right to use the lake? Why is that significant that it was done in that sequence? So, Esther, let me ask you a follow-up question. Did Adam give Betsy the full bundle of sticks onto Wet Acre? Did he give fee simple absolute? No. Okay, I want everyone to see that, right? The transaction from Adam to Betsy of Wet Acre was not a fee simple absolute. It did not give the full bundle of sticks. Why? Because he reserved one stick in the bundle for himself. I think Esther said this correctly. He reserved the right to cross over and use the lake. So for whatever reason, Adam shows up and Betsy's there. He starts using the lake. Can she call the cops for trespass? The answer is no. Because he has a legal permission, this was called an easement, to cross over. Now, Hadia, let me ask you a follow-up question. What if Adam moves and he no longer owns Dry Acre? He moves to another state. Is he still allowed to go onto Wet Acre to use the lake? Tell me why. And what do you call that? Yes, ma'am. This was called an easement in gross. An easement in gross. The definition of easement in gross is that the easement benefits a specific person, not a piece of land. Right? So kind of a trick question, but not really. I'm asking, what is the dominant estate? Roxy, why is it somewhat of a trick question? Well, Roxy, with an easement in gross, is there a dominant estate? No. Why not?
Because the benefit attaches to the person.
Exactly. Okay. So, Edwin, tell me again, what's the difference between a dominant estate and a servient estate?
The dominant is the one that gives, the servient is the one that takes.
Okay, so in this fact pattern here, what's a servient estate?
The servient estate would be Dryacre if that was what it was given.
Why? So you're right. Why is Dryacre servient here?
Because the right to take water would be attached
Bingo.
to Dryacre.
Yes. The property that's doing the serving, water in this case, is a servient estate. But Roxy's correct. There is no dominant estate with an easement in gross because the benefit doesn't go to the owner of Dryacre. It goes personally to Adam. So the answer is none of the above. Let's see how you guys did in this one. Oh, pretty good. About 60%. Pretty good. A couple of you put Adam. That wasn't right. But yeah, but 60%. That's the normal distribution. Very good. More people are in the room than voted, but that's usually how it goes. Okay. So any questions about that? So make sure you keep in mind for your notes and for the exam the differences between an easement in gross and easement appurtenant, and don't say with an easement in gross that there is a dominant tenement or a dominant estate because it doesn't exist. There is no such thing. All right, any questions on that? Okay. So in our last class, we discussed people who actually created easements. In one case, we had a case where the woman wanted to reserve an easement for parking for a third party, and she did it by written instrument, and that was allowed. In another case, we had the issue of a license, that is an oral permission to use property, and what are the circumstances when oral license can be revoked. Today, we're going to be doing a couple cases that involve an implied easement. An implied easement, right? Costa, what does implied mean generally in the law?
Like a given, in this case, would be a given that you are allowed to cross. It's implied. There's no.
Define it without defining it. Defining without using the word. What does implied mean? In general, in law school, use this word in a lot of your courses.
It's no, they're given. They're given.
Not quite, Lucas. Implied. Well, let me try this, Lucas. What's the opposite of implied?
Explicit.
Express. Good. Okay. So what does express mean?
That a person or something is expressly
See?
said. It's
Okay. I'll give you said, right? With an easement that's expressed, it's written, right? It satisfies a statute of frauds, and that might be one way you can understand it, right? If something's expressed, it will satisfy the statute of frauds. Why? It's written. Has a signature. Parties are bound. The opposite of express is implied. And implied simply means not written. Right? Courts instead will pretend it was written based on the circumstances. Right? It might be based on fairness, what's often called Estoppel. It might be what's called the Doctrine of Necessity, which we'll talk about later today. But with easements, courts can actually create an easement. Okay, now Justin, what's the difficulty when courts start implying easements? Why, as a property owner, maybe you're not happy about that when a court implies an easement?
Because it can mean that oftentimes you don't necessarily have a say in what the easement is given about.
And what does that do to the value of the land of the property owner?
Appreciates it.
Diminishes it. And specifically, what does it do to your bundle of sticks?
Takes some of it.
Exactly, right? So here's the rub with an implied easement. You're basically taking someone's fee simple absolute and you're yanking a stick out of that bundle. Right? The person had a fee simple, could exclude whoever he wants, right? The most valuable stick in the bundle is right of exclusion. When you imply an easement, you diminish the power to exclude. right? And Samantha, if someone wants to cross across your property, what might you ask of them? Money. Money, pay me for it, right? Pay me for the easement. But with an easement, you get paid? They may not have to pay you. Sometimes they might, but let's just say as a general matter, right? If there is an easement implied, the court may not require compensation. Sometimes yes, but just as a general rule, no. So it sucks doubly. First, you have to litigate the issue, right? You have to go to court, hire a lawyer, jump through all these hoops. But second, I think Samantha's correct. You're losing value in your property, and you're probably not getting compensated for it. And anyone who buys Blackacre from Samantha, for example, is now obligated to accept this easement. It runs with the land. That's the phrase which you have to get into your vocabulary. It runs with the land. And as a result, you're stuck with them. You're stuck with Mr. Whoever, Adam, crossing out your land to get water. Okay? So the book discusses two types of implied easements. The first is what's called a quasi easement. Quasi easement. And I'll spell it. You see this word quasi in a lot of your courses. Marcelo, do you remember this word quasi, what this word means? We've seen it in a couple different cases, I think, the last year or so. Quasi. Yeah, exactly. Kind of, right? Not exactly. Kind of. I actually like that word. Kind of. Right? Yeah, somewhere in the middle. So quasi means not exactly, but kind of. And quasi easement means it's implied from prior use. Right? That if there are expectations and people have been using it for a certain way for a certain period of time, the courts say, let's let people keep using it. Now, there's something that should be ringing in your head, Kendall. If you keep using land for a period of time in a certain way, you keep crossing over it, what should that accomplish, right? What should that be? What do you call that? If you keep doing everything, keep walking across that land every day for a year and 10 years and whatever, what do you call that? What's that word? Prescription, exactly. Prescription is like eminent domain for easements. That's how you have to think about it, right? Prescription is like eminent domain for easements. If you keep crossing over Blackacre every day for a decade, eventually you get a prescriptive right to Blackacre. But a quasi easement is something different. It means you didn't satisfy all the requirements of prescription, but we'll give it to you anyway. Right? You kept using it for a long time, maybe with permission. And if it's with permission, you don't get prescription. Or maybe you only use it for 9 years and not 10 years. Or maybe you don't have the right state of mind, depending on the jurisdictions. You don't have a hostile, aggressive trespasser standard. So the quasi easement is like a backup, where maybe you could get prescription, but not quite. But again, the quasi easement means it's implied from a prior existing use. There's a case which I don't assign anymore called Van Sant versus Royster. You can read it if you want, but it illustrates that point. Okay. So any questions on the quasi easements? Again, I didn't give you a case on it, but they're pretty straightforward. It's basically you're using it, you don't quite meet the standards of a prescription, but the court gives it to you anyway as an equitable matter. Which again, if you think about it, if you can just sneak in the back door of quasi easements, what's the big deal of this prescription? All these 4-factor tests, so it's somewhat looser. Okay. So the next type of implied easement that I want to talk about is what's called the easement by necessity. The easement by necessity. And in these cases, the courts will imply an easement where it's necessary to enjoy some piece of land. But specifically, and this is an important point, the necessity has to arise when there's some sort of severance. Okay, and this just keep this in mind because students often apply the necessity doctrine where it really shouldn't apply. The necessity doctrine only applies where the problem came after some piece of land was severed. That you had a big piece of land with something, with a benefit, maybe a road, and then you chopped it up so that the second piece of land no longer had access to the road. So again, the necessity doctrine, you can't apply this in all contexts. Generally, it applies when land is being severed or divided up. And we'll see in the first case, the Texas case, how this happens. Yeah, Reed. I'm sorry, Jake.
I have a question going back to the Quasi.
Yes, sir.
What's the difference between that and the Estoppel? It seems very similar.
Real similar, right? Let me. So Jake's question was this, right? What's the difference between Estoppel? I said Jake. Jake, right?
I'm right, sorry.
You don't have a name tag, no? Okay, come on. You have no name tag. This is not. Okay, fine. There you are. Thank you, Ryan. Look, you got to work with me, guys. I do my best. I try. So the question was this from Ryan. Thank you. The difference between Estoppel and Quasi Easements. There's not much. You have a rule, prescription. There are the 4 factors, right? Open, notorious, continuous, claim of right. You know those things, right? Courts make up exceptions that even if you can't squeeze into the 4 factors of prescription, they can still tap dance around it. And maybe they'll call it estoppel because of fairness. Or they'll say, well, it's not just estoppel, it's quasi easement because, you had 9 out of 10 years is close enough. So, if you think of it as like a levels of difficulty, prescription's up here, quasi easement's like over here, and then estoppel's here, where it's just like complete fairness. So at least quasi easement has some law behind it, whereas estoppel is just this ain't fair. Does that make sense? Okay, thank you for the question. But yeah, they're really similar, and don't kill yourself. And even the necessity doctrine has a lot of fairness built into it. It's a little bit more. You can define what the problem is because you can't get the road access. Okay. Now you should know that the necessity doctrine has different rules about how necessary something should be. So the case we have today is from Texas. The Texas doctrine, as you probably would understand, requires what's called strict necessity. Strict necessity. Khadijah, tell me please, what does strict necessity mean? Yeah, she's right. It means that courts will only apply an easement when it's absolutely necessary and there's no other conceivable way, short of getting a helicopter or something, right, for you to access the main road. We'll discuss in the Texas case how strict the standard is. But the majority rule, and what's in most other states, I think at least, is what's called perhaps reasonable necessity. A reasonable necessity, which is a little bit easier to satisfy, right? It's got to be really important, but they're not going to require you to buy helicopters as an alternate. Okay? All right, so any questions on that? All right. Lance, you want to give me the facts, please, in the first case, Avin versus Rosier?
Yeah, so there's 2,493 acres was all owned by the Simon Hill.
Okay.
And he conveyed it like in pieces.
Yeah. Just walk me through, and I'll come back and clean it up.
Some of it came in the hands of the respondent, and the rest came in the hands of the petitioner.
Okay.
And basically the only way for the petitioner to get to the main road was by crossing through the respondent's portion of the land.
Okay, very good. So let's walk through the facts one step at a time. When you think about this case, I want you to keep in mind one principle. Generally, people are not understood to be stupid. They might be, right? But as a general premise, we presume people aren't dumb. You might disagree. Why does this matter? we presume that when someone's selling or chopping up their land, they're not trying to block themselves in to make their land worthless. You understand what I'm saying? When someone's chopping up their land and dividing up their parcel, we presume that they're not going to block themselves in where they can't leave their property without a helicopter. Right? Just, we presume. Now, that may not be the case. Perhaps someone doesn't really care about this land and just wants to make an easy buck and maybe will pay for an easement or something. I don't know. But why is this then important? Let's go back to the question that I gave to you at the outset of the class. I said it in a very specific fashion. I said, Adam owns wet acre and dry acre, and he conveys wet acre with the right to cross onto it. So what does that mean? He didn't just sell wet acre to Betsy hoping to negotiate an easement in the future, right? Maybe he could negotiate an easement in the future, maybe not. He said, I'm selling it to you with the condition, what's called a reservation, right? With the reservation that I cross over. So the basis of the Ogden case, what makes it a little bit tricky, is we have to try and get inside the mind of the seller and saying, when he made this transaction, would he have intended to reserve an easement for himself? He didn't actually do it. But do we intend, did he intend in his mind to reserve an easement? Even though he didn't do it, right? There was no actual easement reserved. We try and see what was going on in this guy's head. So let's go through this one step at a time. You all see this animation. It's on the board. The book has this lovely website, which they don't make available to students, which I don't know why. But it's like all these graphics and stuff. So there's actually it's an animation animation, but a slideshow basically. So we have this plot of land. This is Bell Line Road. This is the main road, and you have this huge plot of green called the Tone Survey. And it was 2,500 acres. Is that a lot? 2,500 acres? Is that big? Yeah. Okay. I guess I don't know. I still can't internalize acres every year I teach. I have no idea what that means, but it's a lot of acres. Okay, so Hill is a current owner, and there are a series of transactions. So the first transaction, Hill sold 100 acres in 1896 to Rosier. Okay? So Hill sold 100 acres in 1896 to Rosier. It was actually given to Rosier's predecessor in interest. Rosier got it in 1924, but that actually doesn't matter. And I'm just, by the way, the word M-E-S-N-E, did anyone look that word up? What does that mean?
It's kind of like a middleman.
Yeah, it's pronounced mean, even though it says no, it's not mesne, it's pronounced mean, and it means intermediary. So I don't really care who the intermediaries are. All I care about is Rosier, because he's the party in the case. So the first transaction is that Hill sold to Rosier 100 acres. Okay, if you notice, this blue block is right on the main road. So at this point, Hill still had access to the main road, right? Everyone with me, right? Hill can go like this to get to the main road, and Hill can go like this to get to the main road. Everyone with me? Okay, very good. Step number 2. Okay. In 1897, Hill sold 60 acres, this pink block, to Ogden's predecessor, and then Ogden got it a couple decades later. Okay? So at this point, does Hill still have access to the main road? I think the answer is yes, right? Hill can go like this, or Hill can go like that. So far, I don't think there's any problem. Okay, number 3. Okay. Hill sold 53 acres in 1899 to Ogden's predecessor, then Ogden got it years later. Again, Hill, I think, can still access all the land. But what about Rosin? I'm sorry, what about Othen? Well, can't really go like that. In theory, you can go like that. All right, so let's go one more. Okay. So at this point, the transaction was made. 16 acres given to Rosier along the bottom. All right? So at this point, Alec, what's Odin's situation like at this point? How is he getting to the main road at this juncture after these transactions are complete?
He's walking across like the line between versions.
So your point, like right over here?
No, up a little bit, right there.
Aha. So let's see, just click one more on the map. Okay. So Odin is crossing across his own land, Rosier, and then the original survey, right? Is that a trespass there, Alec?
Well, he continued to do it, and so it seems like it's prescription, but it's also kind of what his argument is necessity. Like he's boxed in, so he has to be able to.
Okay, let's take it one step at a time, though, right? Does he have permission to cross over that plot from Rosier? No, I don't think he does. Okay? So then what happens, right, is that they do some construction. And there's like all this flooding. And it made the lane impassable. So what actually happened is that Odin sued Rosier for interfering with his right to cross. Everyone just understand, right? Odin sued Rosier for interfering with his right to cross. Right? So there were two issues here. The first is whether there's any sort of implied easement. Okay? So Katie, walk me through the court's analysis about whether there's an implied easement, please.
Okay, so first, they said that you had to prove that it was necessary at the time of the conveyance, being at the time that Hill first conveyed the Rosa land,
Good.
and they said that Albany had the burden to prove that it was necessary for Hill to reach the land when he conveyed it to Rosa.
Mm-hmm.
And that he didn't prove that, even though there's evidence that there was no other means of reaching Alden's land for the past 4 years, but Alden didn't provide evidence about reaching the land from the public road in 1896.
Okay, very good. Katie's right. And let me walk you through this one step at a time. At every juncture, we ask ourselves, is the seller an idiot, right? Is Hill stupid? Would Hill make a transaction that blocked him in? We don't care about the buyer. The buyer can go buy a useless piece of land. But will the seller do it? So let's go back to our chronology one more time. I want to walk this one more time with you all. So the first transaction was 100 acres of land, right? Hill has plenty of way to get to the road. There's no reason why he would reserve an easement across here. There'd be no reason. Therefore, there's no reserve easement. Second, again, Hill sold this 60 acres to Odin. There's no reason why he would reserve an easement in this transaction in 1897. Okay? We have another transaction in 1899. There's no reason why he would reserve an easement here either, because he can go top or bottom. Doesn't need it. And then again, this last transaction, the light blue one, there's no reason why he reserves an easement. He can go top or bottom. So when Odin claims that there's a reserved easement, he's wrong, right? There's no reason why Hill would have reserved any easement in the transaction. Okay? Everyone with me? But that just gets to the question of an implied easement. There isn't any. But Harrison, what about, at least in Texas, an easement by necessity? Right? Poor Mr. Odin is stuck. Why can't the court imply an easement by necessity here for Texas?
Because he can't prove that necessity existed at the time that the land was split up.
Say that again.
Because he can't prove that easement necessity existed at the time when it conveyed.
Well, let's just go back to the chronology, Harris. Let's talk through this. Okay? When he bought the pink lots, didn't the problem exist at that juncture? Wasn't he landlocked from the outset?
Yes.
Right? I think he's right. I mean, he was landlocked from the outset. He probably didn't think about it. Maybe he just wasn't sophisticated, but he was landlocked from the outset. But the key here, Megan, how does Texas go about defining necessity? How does Texas go about defining necessity then? Well, what's the modifier? How does Texas define necessary? What's the word we use in Texas? No, Chelsea? What's the word we use in Texas to define it? There's a majority rule and a minority rule. She's next. Lauren? Strictly, yes, ma'am. Strictly necessary. In Texas, I'll come back to you, Megan, in a minute, but in Texas, you need to have strictly necessary. Megan, does Mr. Oven need the courts to resolve this dispute?
No.
How could this be resolved?
Making a deal with.
Yeah. Show me the money, right? Pay. If he gives Rozier enough money, he'll get his easement. Or maybe he can go south this way, right? Or maybe he can go like this. Or maybe he can go like this, right? There are roads, and I think I have a Google map of it on my class page. But there are various roads that he can access. This is actually what it looks like today. There are various roads that he can access to get there. So in Texas, it's not strictly necessary if there's some sort of arm's length transaction you can make. Right? The courts are hesitant to reserve an easement in violation of a contract. Okay? And there's no implied easement here, so they're not showing necessity. Okay? And I checked this recently. It's still good law. So I think this is still the rule. It's still pretty strict. Now, if this was a different type of jurisdiction, right, Chelsea? If this was a jurisdiction of reasonable necessity, how would the case come out, do you think? Do you think it seems reasonable that a person who knowingly buys property that's landlocked would still be able to go to the court and complain about it?
They still have to be able to access the road.
Then why'd they buy it? Because at the time they made the transaction, it was known, right? This is not like a mystery. It was known at the time of the transaction who was where. So they basically bought a worthless piece of land. Why should the court bail them out? I don't know. Lauren, you were stretching. You were stretching. Oh, I see. Anyone want to add? Anyone think how this one turns out? Anyone? I don't think they went anywhere. Maybe I'm too soft, or maybe I'm too strict. But
I think the argument that like another way would be too expensive, or it would be unreasonable to like, make them make a street.
Maybe I don't know. I mean, this might work under the reasonable necessity doctrine, but this definitely fails the Texas one. Okay. So I'm going to get the application of strictly necessary. It's got to be absolutely necessary. Imagine like you're landlocked and you're like surrounded by a mountain, and there's only one road to get to this, to the down. I think there's even one case reference in the book where if there's like a body of water, you can ride a boat somewhere, which seems crazy, but it's again, the idea is we don't want to reward people who didn't do their homework. That when they purchase a piece of land and they were aware at the time they were landlocked, the court shouldn't bail them out by taking away someone else's bundle of sticks. Which it makes sense. It's a strict doctrine. It's a harsh one, but I think it makes sense. Yeah, Anthony?
So what you're getting at is there's a necessity, because there's no reason that Hill should have sold it.
Yeah. Well, Hill can make the transaction, right? You can sell a piece of land that's worthless. It's the buyer, right? It's the buyer who is at fault. He didn't do his homework. Understand? Okay, any other questions? All right, so let's try prescription then. Rachel, why wasn't there a claim for prescription by Ovid? I'm sorry, louder? Well, the levy results in the flooding, but Ovid was using this land for a number of years, right? Why is that not prescription? And which requirement was not met? Well, Ovid was crossing Rosier's land for a number of years. Why does that not say a claim for prescription? There's an important reason. No, Joey?
Because he had a gap in continuous use.
No, it wasn't just continuity. What factor is lacking? Bingo. Permission. Right? It was permissive. Right? There was no objection until they had some sort of falling out, and then everything went to crap. But for at least most of the time, there was permission. And when you have permission, you can't claim adversity. So there's no claim for prescription. And one last issue, Gabe. What about a license, right? We talked last week about oral licenses, and in certain cases they can't be revoked. What's the issue there? Under what circumstances can oral license not be revoked? It's mentioned at the end very briefly of the opinion. It's in there. We did cases saying a license sometimes maybe can't be revoked. Anyone? Mariah? Yeah. So why was there not a claim for estoppel? Gabe? Say that again, Gabe? I didn't hear you. Yeah, I didn't. Okay. Anyone else? Why is there not enough for estoppel in this case for an implied, an irrevocable license? They mentioned it really briefly at the end of the case. What does estoppel require? Right?
Reliance.
Yes, ma'am. The answer is reliance, right? So there was enough reliance with respect to it. He didn't pave the road, right? He didn't put down markers. He kind of just crossed over it. Had he started actually paving that road to make it easy for him to cross, I think the case may have turned out a little bit differently. With those 1890s, I don't know if there was even cars in this area of Texas, maybe not, maybe just horses. But there was enough for a reliance. And so the court rejects the idea that the license can't be revoked. So poor Mr. Ovid lost top to bottom. Okay. What else? All right, so again, at least in Texas, which is probably the only thing you actually care about, although, just one point, if this UB thing goes forward, all this Texas-specific stuff I'm teaching is not going to be tested in the bar. It's going to be a very strange thing. It won't matter, right? You'll just, I think, be tested generally majority of rules, whatever that happens to be. So she's going yes. Anyway, it's a thing.
I thought it was the majority law. Doesn't the note say that it is?
Yeah, but I mean, all these times I teach the Texas-specific rule that not is majority, you just not come to know it anymore. Very different. I don't know how I feel about it. I'm still conflicted as a federalist. It makes me not happy. All right. I like states having different rules. Reminds people they're states. Law students hate them, though. You want uniform, everything the same. No. It's experimentation, a laboratory's democracy, as Brandeis would say. Not with ice cream. You know, the laboratory's democracy came from a case called Liebman versus New Ice. And actually the state had a law saying that you need a license to sell ice. And basically only a couple companies who have a monopoly to sell ice. So that experimentation I'm not a fan of, but generally it's good. It's frozen water. You need a license to sell frozen water. No, it's frozen water. You don't need a license. Anyway. Anything else on Otham versus Razier? Okay, we'll move on. Okay. So a couple things to flag from the notes. They give some examples of what strictly necessary means, and there's one example that says if you can build a road for $700,000 down a cliff, then it's not actually strictly necessary to get an implied easement. So I mean, I'm trying to tell you the courts are really tough on this rule. That if you bought a piece of property knowing that you can't get out, sucks for you. Don't go to the courts to bail you out. All right, let's do one of the examples in the notes, please. On page 793, there's this, picture. We'll try and walk through it. Where is it? Here it is. So it's question number 3. But the diagram's on page 793, but I think the question number 3 is actually on the following page. So who am I up to? I think Lauren's next. Lauren, you want to read question number 3 for me, please?
A owns 5 adjoining tracts of forest land, numbered 1 through 5. All 5 lots previously recorded by O as a single tract. A purchased each lot from O in a separate transaction. Lot 1 first, lot 2 second, lot 3 third, lot 4
Okay, good.
Lots 3 and 4 are bounded by a public road on the south. Lot 5 has no access to a public road except through one of the other 4 lots.
Okay, very good. All right, so let me walk you through this one step at a time. And I'll have the picture here so you can look. So originally, A owns all these lots, 1 through 5. There's like a subdivision. Okay? And they're owned by a single person. A bought them in a specific order. He first bought lot number 1. He second bought lot number 2. He third bought lot number 3. Fourth, he bought lot 4. And then last, he bought lot number 5. So, Lauren, what's the obvious problem with lot number 5?
There's no access to the public road.
Okay, it's completely landlocked, right? It's completely landlocked. So, Lauren, what do we presume? So, A then bought 1, 2, 3, and 4. And at some point, someone else owned 5, right? When, I'll just call him O, right, the OG. When the OG had lot 5 and he sold it, what do we presume happened at that point? What do we presume?
When O sold it to A.
Yeah, when he sold lot number 5. What do we presume happened at that point?
A had access to the public road because he owned the whole piece of property.
But once, Lauren, O sold number 4, wasn't he trapped? In other words, at what point, Lauren, was O trapped?
After the sale of 4.
Ah. So I want everyone to get this, right? As soon as O sold lot number 4, he was trapped. And again, we presume people are not stupid. Maybe it's not true. Maybe it's an unwarranted assumption. People are laughing. Whatever. Don't be so cynical. We presume people are not dumb. So, Lauren, just finish it up. What do we presume O did when he sold lot number 4?
He went on one of the other 4 pieces of property to access the public road.
But specifically, when O sold lot number 4, what do we presume he did with that transaction? Think back to our question at the start of class today.
I'm not sure.
Daniel?
He preserved an easement.
I think that's right. Yeah, he reserved an easement. I think when Lot 4 was purchased from O, you have to have a quasi easement there, either through implied or necessity. I think either way would probably work. But you say that O would not be so dumb to sell lot number 4 and be stuck with 5. So O reserved an easement. It's implied. It wasn't done expressly. We say he reserved an easement that allows the owner of 5 to cross 4 and get to the main road. Now, is this done by an implied easement, or is it done by quasi easement, or is it done by necessity? I think all roads lead to the same place here, right? This is a situation where you literally would need a helicopter to get on. I mean, there's no way to get to the road. You're stuck. So I think you'd probably have an implied easement, perhaps even an easement by necessity. I think implied is probably more likely because, again, whoever knowingly buys lot 5 without having an easement is an idiot. So I think probably the implied easement is a better route. So we say that there's an implied easement on the sale of 4 to 5. Okay? Okay. All right. Oh, yes, Brittany.
You said from 4 to 5?
I'm sorry, from 5 across 4. Sorry. Yeah, basically, let me ask it like this, right? So we have lot 5 and lot 4. Michelle, which one's the dominant tenement, or the dominant estate, and which one's servient in this case? Yeah. That's why is 5 dominant? Yes, ma'am. Which one's servient? Exactly. Everyone understand that, right? In this case, it's an easement appurtenant. It's not an easement in gross. And I think the easement stays with lot 5 as the dominant tenement, and then lot number 4 remains the servient tenement because it's getting crossed across. This is not a case where it's assignable, right? One thing about an easement by necessity or an implied easement, they only exist so long as necessary. You know, let's just say, I don't know, that person number 3 sells an easement to number 5. At that point, if they have a way to get across, that easement by necessity dissolves. So again, an easement by necessity only exists in like a judicial state. It's not permanent. And if for whatever reason that easement no longer needs to survive. I'll give you an example. Anne, what happens if the same person owns lots 4 and 5? What happens to that easement by necessity?
It goes away.
Why?
Because it's not needed.
Why is it not needed?
Because it's owned by the same person, so presumably he doesn't need an easement against himself.
You can't trespass yourself, right? Yeah, Anne's exactly right. If for whatever reason the same person bought 4 and 5, it would dissolve the easement by necessity. There's just no easement for it. There's no need for it because the same person owns both lands. Okay. Is there any questions on that? Yeah, Brittany.
Just so I have it in my notes correctly, I feel like I missed a word. You said O reserved an easement for lot 4.
For the benefit of lot 5 across lot 4. The easement, that's why it's dominant tenement, right? The dominant tenement there, or the dominant estate was lot 4, and servient was 5. No, I reversed it. I'm sorry. The dominant tenement was 5, and the servient was 4. Right? So when O sold lot number 4 to A, he reserved an easement for himself from 5 to 4 to get out. The reservation happened in the sale of lot 4. That make sense?
Yes.
Okay, very good. Thank you. Okay. Yeah, Andres.
So if Rome was smart enough, he could have easily made an easement with lots 1, 2, or 3 before
We'd have to pay for it though, right?
Right.
That's the catch. The business of implied or reserved easements is you don't pay for them. He could have said, look, I'm going to keep lot 5, and I'm going to keep an easement here, an easement there, an easement there, an easement everywhere, right? But you have to pay for it. And you have to basically take someone's stick away. Here, lot 5 was sold without any concern for this trespass issue. Make sense?
Yeah.
Okay. Anything else in this diagram? A little tricky, but I think this diagram explains the Ogden case a heck of a lot easier than the actual Ogden case. It just makes it a little bit cleaner. Anything else? All right, let's move on.
don't worry about the suspect prescription in governments, and don't worry about the the golf ball thing. It's a weird example. I don't know why they put it there, but it's in there. All right, so let's go on to beach access. Flip your pages. They reorganized the book, and I didn't like what they did. They used to have the beach easement thing in the easement chapter, but they decided to put it all the way to the front of the book in a topic on the public trust and public domain. I don't know why they did this. They're trying to make the book more modern, and I don't know. I think it worked fine before. I always complain whenever they change the book. But this is what happens. All right, so the beach is a odd area property law. So this meme gets dated, but as a Staten Island resident, I still chuckle. Most of the Jersey Shore cats were actually from Staten Island, by the way. They weren't actually from New Jersey, so I represent. Okay, you're welcome. Clam. It's water. The water, right? The water is not really owned by any one person. This is a fairly basic aspect of American law. Law doesn't really apply on the high seas. It's what's called international waters. That's why we have things like piracy, and people do gambling, all these other things in international waters where the laws of a nation don't apply. Usually, the laws of a nation apply X numbers of miles from the shore, and whatever that number X actually varies by country, and there's lots of disputes over how far from the shore a country's laws project, and it's not important for this class. What is important for this class is that in American property law, the shore itself is owned by the public, right? A private beach owner cannot exist, right? A person cannot own the area where the water meets the sand. You can't own that area. It belongs to the public trust. Okay? But wait a minute, Josh. Water moves around, right? You have high tide and you have low tide. Sometimes the water goes all the way out, and then sometimes it comes in. And sometimes you have a storm, and the storm can cause what's called erosion, which it might dump a lot of sand on the beach, so that the shoreline goes out, or the opposite may happen. The shoreline may actually move up close to a person's property. So there are different ways of measuring property on a beach, but it's very messy, very messy. So I want to keep in mind a few different portions, right? So you have the water. You have what I'll call the wet sand. This is generally where the water touches the sand. You know, when you walk on it, doesn't really burn your feet, right? This is where the water meets the sand. Then you have the dry sand. This is where the water will burn, the sand will burn your feet. It's very hot. But then at some point, if you keep walking, you see vegetation, right? Why is vegetation significant? Because it means the water doesn't really go there, right? Plants can't grow if seawater is flooding it. It's salt water. It's toxic for plants. So again, you have the water, you have the wet sand, you have the dry sand, and at some point you have vegetation. Okay? So generally, what can be owned privately? The dry sand up to the vegetation, and everything past the vegetation, right? But you can actually own the dry sand, but you can't own the wet sand. Everyone with me so far? Right? You can actually own where the dry sand is. Oh, there's a better picture, right? You can actually own where the dry sand is over here, but you can't have the wet sand, but you can have the vegetation. All right? Why is this important? So let me just give an aside. In Galveston, a number of years ago, one of the hurricanes that came through, one of the consequences of a hurricane is it dumps a lot of sand on the beach. So let's say in the past you had 10 feet of dry sand. And now you have 15 feet of dry sand. Do you now gain that other 5 feet of extra land as your own property? And there's a lot of litigation over this in the Texas Supreme Court that generally the government has to pay you for that extra land if they want to take it, right? They can't just assume it's theirs. Okay. But this creates an issue, right? Let's say that I own all the dry sand in this area. But did I say that the water is public and the wet sand's public? How are people supposed to get from the public street over here to the wet sand? They can't jump, right? You can't do a pole vault over the dry sand. I suppose you could, but it wouldn't be very safe. So a doctrine is developed that says property owners that have dry sand are required to allow passage from the public street down to the wet sand. They're required to allow people to walk across the street from the public street to the to the wet sand. Has anyone ever been to a beach house where it says something like people are allowed to cross between 9 a.m. and 5 p.m.? You ever see these sorts of signs? There's a reason why. Anyone want to guess why people who own these beautiful, expensive beach houses say you can cross between 9 and 5 p.m. and any such thing? You want to guess why? From sundown to sunrise, whatever it is, sunrise to sundown? Yeah.
Because they're given permission and they can revoke it.
And if it's permission, what can't you do? What's an important aspect of giving permission? Well, now you're just cheating. Just say prescription, yeah. By giving permission to cross from the public road to the wet sand, you're killing any claim for adverse possession. Right? You're killing any claim for adverse possession. And that's an important factor because if you cross someone's property every day for a decade, you can now claim an easement. So in almost every beach house you'll go to, you're probably noticed, but you'll see a sign that says you can cross over, under certain conditions. Right? And they can't deny you. So the New Jersey case, right, and what's going to happen for New Jersey. They can reverse the common law. There's just no doubt. What's going to happen. But this New Jersey case, Matthews versus Bayhead, isn't about crossing from the main street down to the wet sand. It's about something else. Right, Joyce? What is the New Jersey case about? It's not just crossing the street and getting to the wet sand. What are they trying to get set up here?
I think they're trying to get access to to enjoy the property too.
The beach club.
Yeah.
The private beach club. Again, they're required to let people pass across. But Joyce, what do the people want to do here in this case? Where do they want to chill?
Where do they want to chill?
Yeah. On the sand. They want to stay in the dry sand, right? It's like, look, we're all wet. We want to dry it off. It's New Jersey. They want to go tanning, right? It's a Jersey thing you would not understand. Wouldn't understand. But this is actually a verbatim quote from a New Jersey Supreme Court decision. The law protects the right to sunbathe and enjoy anyway, Jersey. So, Joyce is right. This case isn't just about the right to cross over. In this case, the neighbors want to actually use the dry facilities. Now, they don't want to access the beach club itself, right? They don't want to walk into the club and go to the bar and do whatever people do in New Jersey, right? They want to just go on the sand. Now, I always make this point, not to diminish their claim, but to mock it somewhat. There's lots of public beaches in this area. There are lots of them, right? If they walk a couple blocks over, they have a public beach they can sit at. But they were, I think, opposed to the very notion that a beach club could exclude anyone from the dry sand under any circumstances. Even though they have, chairs and web regulation, they want to limit it. So, Citra, walk me through this case a little bit. Just give me the facts.
So basically, it was the Borough Point Pleasant filed a suit against Bayhead and the association, asserting that the people of Point
plan.
Mhm.
And then so basically public advocate.
What's a public advocate? Does anyone know what the hell this is? Who is this guy, the public advocate? They don't even. Who's a public advocate?
Nominates or chooses to represent them, like as their voice.
Yeah, it's a weird thing. I don't really understand what it is, but it's basically an office in New Jersey that advocates on behalf of the people, right? It's not really like an elected official, but they're usually appointed to like represent the people in these sorts of disputes. New Jersey law is very strange. If you remember the Mount Laurel case last year, this was a zoning case. There's lots of really weird things in New Jersey law where they let people come to court. It's strange. But anyway, it's a Jersey thing. Anyway, thanks, Sandra. So, Jenica, what happens here? How does the court respond to their claim, the advocate's claim, that they not only have a right to vertical access to the water, but also horizontal or lateral? Lateral means horizontal. Lateral access to the dry sand.
So the court doesn't like it. Essentially, they look back at like older law and they say, listen, even from past time, there's the law of the sea. I guess
The law of the sea.
They're kind of saying this has not been a thing. You should have the right to enjoy this beach. You can exclude people or cause them or charge them excessive prices just because you feel that you have a special membership and all that.
Very good. So the court basically holds that not only does the law require vertical access to the beach, but also requires horizontal access. And even if you have a private club, you cannot have a selective membership. Now, Marcos, excuse me, is the club allowed to charge a fee for accessing this, the dry sand?
The club? Oh no, the club, because the club in this case, they could they would generally accept pretty much anyone who applied, and but they would charge people who try to access the beach outside the hours that they were limited to. But yeah.
So, but are they allowed to charge a fee?
Yeah.
Yeah. So the way it works now, and I've looked into this, the state of New Jersey actually sets a fee schedule, and they tell beach clubs what they can charge. So, maybe in the past a beach club had like lifeguards and folding chairs and umbrellas, but now they probably have to do less because the fees are pretty low. And when I was a kid, I didn't even know this, but I actually paid, it's like $5. It wasn't a lot for admission to a New Jersey beach. And I don't even know why, but now I know why I did that. So, you have these nice posh clubs, but now they have to basically open up and they have to charge a reduced fee. Aaron, did the beach club have any compensation for the lost profits from charging these fees and any other losses to their business?
They have compensation.
Yeah.
Other than the public paying to
Yeah. This is a case where New Jersey diminished the value of the beach club, but for reasons we'll cite later this semester, there's no compensation for it. Because they still have some profits that can be made, the courts have held that there's no taking under the Fifth Amendment. All right. So, all right. Any question on this case? Yeah, Aaron.
So they can now charge a fee to access the dry sand, but do you have to pay the fee if you're just using the easement to get to the wet sand?
No. I think if you go right from the public street to the wet sand, you don't have to pay anything. That's still free.
But if you hang out in the dry sand?
If you want to go put down a towel and whatever, yeah. All right, so let me summarize. That's all I got for today, so we got a little bit easier. The general rule is that courts will imply an easement if there's some sort of fairness or necessity, but the rules do vary. And in Texas, the strict necessity standard is quite high. Meanwhile, in New Jersey, if you want to go tanning, you get an easement just for that. So you can see there's a very wide range of how the courts approach this doctrine. Any other questions? All right, I'll see you guys on Monday. Thank you very much.